Good afternoon, Texas Legal. My name is Melissa StoneMyers. I am with StoneMyers Law. I am an estate planning attorney based in Southwest Austin. And today I am happy to be here, and I appreciate you having me and appreciate Texas Legal for having me. And we will be talking about moving to Texas and updating your estate plan and some things you need to know. I am going to try to get through some questions. I'm going to try to take them at the end. So if you have questions, please go ahead and put them in the chat. My information and Texas Legal's information will also be in the chat as well. So a little bit about Texas Legal. Texas Legal is a statewide nonprofit legal benefit plan. It was founded by the State Bar of Texas to better meet the legal needs of Texans. Texas Legal provides members with access to over 400 network attorneys, along with various insurance plan options. Texas Legal offers members the abilities to create or update their estate plans once per year. And the contact for Texas Legal, as I mentioned, will be in the comments and description box of this webinar. Please contact Texas Legal for more information on plans and benefits. So I wanted to let you know a little bit about me. And since the topic of our discussion is moving, I have moved several times. I think we've lived in 5 or 6 states. And it started back in '95. I was living in upstate New York. I went to college at the University of Albany, and I was a STEM major. I was biochemistry. And right after college, I went on to law school in Boston, Boston University School of Law, and I wanted to continue my science and law, so I focused on intellectual property law. And in 1998, I graduated, I took the Massachusetts bar and passed it, became licensed in Massachusetts, and began working in the energy sector in-house doing in the legal department. My husband was still finishing grad school, so we weren't exactly sure where we were going to ultimately end up. We did ultimately move to Pennsylvania, so another move, and yes, another bar exam. And while we were in Pennsylvania, I began working in intellectual property at a firm in Delaware, because back on the East Coast, you can actually live in one state and work in another. So I was licensed in Delaware and Pennsylvania, worked there for several years, and then in 2006, our family relocated to Texas, Austin, and I began working, or continued working, but remotely, for my firm in Delaware. So before Zoom was a thing, before work remotely was a thing, I was doing it. However, in 2013, I was getting a little restless. My kids were getting older, and I wanted to do something a little bit more client-facing. And I had also having children, where we don't live near them, I would worry about things such as travel or what's going to happen if something happens to us, who's going to take care of our children. And from all those different bar exams, one area of the law that would sort of fit that worry or be able to address that worry was estate planning. So doing wills, guardianship, trusts, things like that, that would be something, it would be a plan I could put in place to make sure that I couldn't really prevent things from going wrong, but at least I would have tools in place that if something did go wrong, they could be addressed by the people that we knew and trusted to do those things. But in addition to me having these issues and worries, there were lots of fellow moms and dads that I was meeting along the way here that also worried and weren't really sure how to address these things. And so I was motivated. I took the Texas bar in 2013, passed it, and decided, you know what, I'm going to take a turn in my life and I'm going to start practicing in an area of estate planning where I can actually help people and I can help people achieve peace of mind. So in 2014, I formed the firm I'm at now, StoneMyers Law, and I focused on estate planning and business planning. Also in 2014, I became a Texas Legal member attorney. And then in 2022, this year, we celebrated our 8th anniversary, and I'm still a Texas Legal member attorney. And most of our referrals, we've been very lucky, blessed. They are, most of our clients are referral based, so from other clients or people that know us. So y'all aren't here to hear about me, but you're here, here to learn about moving to Texas and things we need to do once we get here. There may be some of you that haven't moved yet, And if not, I've got some tips for you. And for those of you that are already here, some of these may still apply to you. So I'd like to go over them with you. First, if you're moving here from a state that has a you have a revocable trust, please go ahead and let the title company, your current realtor in Texas, know right away that you have a trust, because they can make sure that your new property, your new real estate that you buy in Texas is put into that trust. It's much easier. It'll save you a bunch of money to have them do it rather than have to contact someone and have them create a deed and do it later. Another thing before you move and you're getting all the boxes ready, like this cute little family, make sure that there's certain things you do not put in the boxes, like the way you wouldn't probably put your jewelry, money. You also don't want to put your estate planning documents into those boxes. You want to make sure you carry the originals with you. So number one, you have them. Better yet, if possible, if you have hard copies, go ahead and take them to a Staples or Kinko's or something and get them scanned so you have PDF files of everything. And you should travel with those documents. And for those medicals that I mentioned, best practice would be to get them to your new doctors as soon as possible. So make sure that your new doctors have your medical documents that are already in existence. And if you don't have them yet, no worries. You can get them done here in Texas with your estate planning attorney. And speaking of, one of the things you should do is make an appointment with an estate planning attorney to have your documents reviewed with a view to Texas law and what might need to be updated. So when we talk about appointments, I get a lot of calls, and there's clients that are very nervous about meeting with an attorney. It might be the first time, and they're really not sure what they need to do. And there's really not a lot they need to do. The hardest step we tell them is making the appointment in the first place. Once you've done that, everything else is easy. It truly is. It's very straightforward. So make the appointment to have your documents reviewed. And if you don't have documents, great, make an appointment to have new documents created. Before that appointment, try to drop off copies of those documents to be looked at. Do not drop off originals. You always should be the master of your own originals. Do not let anyone else have them. You need to keep possession of them. Better practice, if you had made the scans of your originals, you could send instead by email PDFs to your attorney. Know right away that if the attorney says we can't update this or it needs to be done new, they're not giving you bad advice. They're giving you good advice. There's certain documents that cannot be amended. There's certain documents that can. So powers of attorney, medical powers of attorney, those things have to be done new, whereas trusts and to some extent wills can be amended. And we'll talk about that a little bit later. Do ask for forms ahead of time that can be filled out. There's clients like we have on our website, we have client information sheets. That gives the attorney some idea of what you're looking for, what's your goal of the appointment, whether you've done a plan before or not, just a little bit about the nature of your family. And then if there are some planning forms that can be filled out, it gives you an idea of kind of review what sorts of things you might be talking about with the attorney. And then giving the attorney this information will help better use their time with you. And so you have a better focused discussion. So as we talk about the documents, well, what are the documents we need to talk about? So first, medical. There are 3 medical documents. They're all related. The first of them being a medical power of attorney. This is the document that allows you to designate someone else to be your medical advocate, right? So if you're ever in an accident, you're ever unconscious, there needs to be someone your doctor can talk to on your behalf. That's your medical power of attorney. In an ideal world, you would have one person designated as a primary and a couple of alternates. So in case that first person's not around or can't be reached, you've got some backups in place. In addition to that medical power of attorney, you want to make sure you give that person access to your medical records so that any conversation with the doctor can be fully informed, right? And so that consent is HIPAA. The HIPAA laws were passed in '96 to make sure that no medical information was disseminated without consent. So we want to make sure that our medical agent, our medical power of attorney, has that ability to have full informed discussions with our doctor. In addition to those two, there's something called a living will. In Texas, it's called a directive to physicians. And what that document is it's one where you're asked to make a choice about some potential future hypothetical event. That hypothetical event is if you later in life are ever designated as incapacitated and fatal. So a doctor has determined that you have a fatal condition. And in addition to that, you are unable to make decisions. You're unconscious, you're in a vegetative state, you're a coma, something where you're not going to be able to come awake again to make decisions. The doctor is going to need to know whether or not to give you life support. The living will is the document that tells the doctors what to do. Okay, in the absence of a living will, if you don't have one, then your medical power of attorney will make this decision for you as well. Okay, that's a lot to unpack. The next, I want to move over now to finances. While you're alive, you should also make sure you have a durable power of attorney. If you moved here, it's possible you had a specific power of attorney that was used for the sale of your home or purchase of your home, whether or not you were able to attend closing. The power of attorney I'm talking about is a financial document that allows someone else to be able to pay bills on your behalf, be able to talk to credit card companies, utility companies, tax professionals, financial advisors, anything that's real estate or financial related. That's what the power of attorney governs. So we're allowing someone else to be able to speak to these institutions on our behalf and make decisions for us. It's generally advisable to make a power of attorney what we call effective immediately, and the lawyer you talk to can talk with you about that, but maybe you would just want to make a note to ask about that. And it essentially means that the power of attorney is effective the moment you sign it, rather than becoming effective only upon your diagnosis of incapacity. Because we're a world where there's lots of things that happen, and the last thing we want is for someone to have to go get our medical diagnosis that we're incapacitated prior to them being able to pay a bill for us. Okay, I'm going to transition to talking about another document, and this one is a little bit more unique to Texas. There's something called guardianship or declaration of guardianship in the event of pre-need. If any of you have young kids, you may have thought about who's going to care for my children if something happens to me. We will address that. This document instead is anyone over 18, if that person over 18 loses the ability to know right from wrong, to be able to care for themselves, maybe they're a danger to others or themselves, they might need a surrogate caregiver. Okay, that surrogate caregiver, that's their guardian. That's the person, if you think of it almost like your surrogate brain, that's the person that's going to make sure the person that needs the care, maybe they're admitted to an assisted living facility, maybe there's a memory care unit, maybe there's nurses that they can get to help, but it's making sure that you have the care that you need. So you can pre-designate on this document who your guardian should be should you ever need that. Another document, oh, and one more thing on the guardianship. It's not enough to just have on paper, mom's guardian is going to be son Jamie. And Jamie can't just say, oh, mom, you're acting a little, you're not making sense. I'm going to go ahead and be your guardian. It doesn't work that way. Jamie, if he was the person that was going to be mom's guardian, would institute what we call the guardianship process. So he would have to get mom evaluated. There would have to be a physician's diagnosis. And then they would apply to the court to have a hearing. There would be an investigation done. And then ultimately, the judge, based on the facts and evidence about mom, would figure out, does mom actually need a guardian? And then is Jamie really best fit to be her guardian? So there is actually a process. All right, the next document I'm going to talk about will then transition us to talking about decisions upon death. And that is the appointment for disposition of remains. This is the document where we can ahead of time state who we want to carry out our wishes, whether they be burial or cremation, funeral service or not, whatever it is that we might want. I had a client the other day that wanted to write in perhaps like what the Psalms might be, or what people were going to eat at at the celebration of her life. You can do all of that, but we have to make sure we have someone that's going to be carrying out those wishes for us. So this document is one where we allow someone to take over for us, to make those decisions for us at our death. Speaking of at our death, we have to make sure we have a will. A will is the very basic document. It's recognized all over the world. It does vary from state to state. In Texas, to have a will, you have to have it witnessed by 2 disinterested witnesses, and you can self-prove the will with a notary also signing it as well. So what a will does is it's a document that allows you to say who's in control of making decisions upon your death, the executor, who the beneficiaries are, and then potentially if you have minor children, we're going to list the guardian of the minor children, and potentially who's going to care for money for the minor children. So all of those people would be listed in your will. So your will is going to explain or list out, tell your story of, if I die, maybe I'm giving everything to my spouse. And then if my spouse predeceases me, maybe everything goes to my children, subject to being held or managed by a trust for their benefit until they're 25. That would be a story in a will. That would be someone explaining what's going to happen. And the who is the executor. That's the person that's going to make sure that will gets validated, goes through the probate process. Then you might have the guardian of the children. That's the person that's going to take care of the children. And then there's a role of a trustee. So when I'm talking about trust here, think little trust. So think of the trust that's part of the will, and a will can have this. And this is where you would say, if something happens to my children, they're under a certain age, then I don't want them having access to money, and maybe they can't. I want instead this other person to manage it, spend it on their health or education, maintenance until they reach that certain age. So what the probate process is when someone dies, we need someone, the executor, to contact an attorney and take that will through the court channels to get validated by the court, and the executor officially pronounced as executor, appointed as executor. So the executor can then go sell the house, empty the bank accounts to give to the beneficiaries, pay bills, pay expenses, pay taxes, and do whatever is necessary to take the deceased name off of his or her property. So when you hear probate, think of someone died, and in order to take their name off of what they owned, there has to be a mechanism to do it, and that's through the court. And in Texas, we're lucky that the probate process is much simpler than some other states. If we have any Californians or former Californians here, Texas probate is nothing like California probate. It's a much simpler, cheaper, more efficient process. So don't be scared if you hear the word probate. But that brings me to, there's something called non-probate. Okay, probate, non-probate, opposites, true. If you have things like retirement and insurance policies, you want to go ahead and make sure that you can update the beneficiaries on those policies, because if you have a beneficiary name on a policy such as these, that policy doesn't have to go through probate. Instead, whoever your beneficiary is can call up the Vanguard or the Charles Schwab or the Northwest Mutual Life Insurance and say, I'm the beneficiary, pay me. And so proving the person died, their death certificate, and some identification of the beneficiary, that check can get cut without ever having to go through the probate process. So be mindful of your different assets and what you have, because if you have things that allow you to put beneficiaries on them, definitely take advantage of doing that. Okay, so I've talked about a will. I want to contrast that to a trust. So if we think that the will is the process of probating in a will, and having a will is a process where when we're gone, we're asking our executor to move things out of our name into the names of the beneficiaries, maybe sell property, etc. The trust works similarly, but all of the work is done by you rather than your executor. Meaning, a trust is almost like, in some ways, it's almost like having a business, and there's things that are owned by the business. With a trust, you're still in control. You're still the owner of your property. You've just, instead of having a home that is in Mary and Jane Smith, the home might be retitled or redeeded to Mary and Jane Smith, trustees of the Smith Family Trust. Well, that doesn't seem like a lot to change things, but it does. Just simply changing the designation and having a trust that you can start funding your property into, if you do it correctly, means you can avoid the probate process, which means you can, instead of going through the court channels, you can have your beneficiaries receive from you in a private manner. Meaning, if you designate someone as your backup trustee, if you're the initial trustee and then you have a backup, when you die, your backup trustee would then immediately step into your shoes, automatically have access to the bank accounts because you've already moved your bank accounts into the name of the trust, automatically already have rights to the real estate because why? You've already funded the trust with the real estate. So now your trustee can start distributing your assets according to your trust document that says who the beneficiaries are, rather than waiting and going through the probate process. Now, again, in Texas, the probate process is not hard. It's not a reason to worry, but that's the difference between a will and a trust. Is with a will, you're going through court to distribute your assets, and with a trust, you're not. You're doing these things privately and you're doing the work ahead of time. All right. You are here trying to figure out whether you need to update certain documents. So let's kind of go through those. With your medical documents, this is a maybe. This is something where if you have existing medical documents, I would take all of them to your Texas doctor and ask the doctor, is there any problem with these documents? If something happened, would you be able to honor and follow these? Know that the living will or medical directive does vary from state to state. And so Texas is very, it's different. It's different than ones I've seen from other states because we do have a set of 2 choices within it, depending on whether someone is expected to live within 6 months or something longer than 6 months. Not every state does because the laws are different from state to state. It's possible that your doctor may not be able to honor a living will done in another state. So please, if you don't want to update it, please ask your doctor if it's something that can be followed, because if it can't be followed, it's better to address that now rather than to think you don't have an effective living will. The next thing is the power of attorney. This is absolutely something you should get updated. If you do not have a Texas power of attorney, you need a Texas power of attorney because banks are not as forgiving as doctors are. Doctors are in the business of saving people. Banks are in the business of making sure that they're doing the right thing. So if they see a power of attorney that was drawn up in Ohio or New York or California, they might reject it or they might send it up to their legal. It's much easier just to get a new power of attorney done so that it's seen by the banks as drawn up on the state law that they're looking at, which is Texas. Wills. So with wills are generally acknowledged from state to state and honored from state to state. However, in Texas, in order for the will to be honored here, it has to be done, it must have been done validly in Texas or validly done in the other state under the other state's law at the time, which means you're going to end up having your the attorney that's helping the executor do research to figure out the other state's law, was it done validly, etc. Research means money. Also, too, your will might address guardianship of your children, but maybe you need to pull it out and think, was the guardian of my children that I listed in my California will someone that lived in California? Is that person going to want to come to Texas? Do I want my kids going back to California to live? So that is probably something you want to think about. And in addition, I mentioned probate is different from state to state. In Texas, the probate is streamlined. So we nominate our executor to act independently. Yes, they initially start through the court process and they are ultimately answerable to the court. However, they don't need the court's permission or blessing to start selling the house or going to the bank. So once the executor gets officially appointed at the hearing, he or she can start acting independently without getting approval along the way. And then also too, if you have moved here, there are good chances that some of the people you listed live in your former state, and maybe you might want to have some local people. Maybe you've changed your asset distribution. So I think it's always a good time to just go ahead and look at your documents just to see if there are some updates. that need to be made. But if you haven't updated your documents, are there any things we really need to worry about? Yes, as I mentioned, the living will, because a living will varies from state to state, your risk is that your living will won't be recognized, which means if you had a living will and you wanted to determine that you didn't want life support, if you don't have a living will, now it's up to your medical power of attorney. And maybe they don't agree with that, and maybe they want you on life support. Well, then it's their decision, because if you don't have a living will, the decision goes on to your medical power of attorney. Also, think about your medical. You want to make sure whoever you have listed, those people are able to be contacted by the doctors and they're still correct, right? So we want to make sure that we've got the correct people listed. So there is some chance that if you don't update it, then the documents are wrong. Maybe the doctors won't have someone to contact. For the power of attorney, as I said, you definitely should get this done. If it's not done and a bank rejects it, there's not any substitute in the law saying, well, if you don't have a power of attorney, no worries, this is what's going to happen. What's going to happen is you're going to need a guardianship, and someone is going to have to get guardianship over you, which, as I mentioned, is a court process. So that's time and money, and it's also very emotional, right? We don't want to have to go through guardianship if we don't have to. With a will, if you don't update your will, as I mentioned, you're going to be most likely your executor is going to be spending estate funds to the attorney to do some research to figure out, was this Idaho will done correctly and validly under Idaho law at the time that it was drawn up? Well, the Texas attorney probably doesn't know Idaho law, so they're going to be doing research to figure that out, to prove up the will, to prove that the will is actually valid. Why don't you save that money, and instead of having your executor spend that out of your estate, just use your plan and update your documents now. And then you don't have to worry about having a will that has to be proven up later. And as I mentioned, guardianship, just make sure that you've got the guardianship updated within your will. Now, trust, a good reason to have a trust updated is there's just a couple of highlight common examples of things that I see often, which is maybe the trust wasn't funded. I talked about putting things into a trust. There are folks that move here and they didn't tell their realtor that they had a trust. So then there's that real estate, that piece of real estate that they bought in Texas, which we know now Texas, because Travis County and the counties all around the state, real estate has really grown in value. You want to make sure that big asset is put into your trust. So we don't want it left out, and now we have to probate. So if you have a trust, go ahead and put it in the trust. So make sure that that's done. And in addition to that, make sure that all of your, we want to make sure that someone's looking at it and making sure that your trust is funded. And in addition, we have homestead laws here. So we want to make sure that there are the homesteading provisions that allows property to be held in trust and that you can still claim your homestead exemption. So there are definitely reasons to update your documents. So in addition to updating your documents, if you happen to have an over 18-year-old that moved here, and maybe you were in the know and you got some documents done for your son or daughter, you want to make sure that they're updated as well. And if you haven't done them, well, you can do them. And as a Texas legal member, that is one of the benefits if you have certain plans, is to be able to get documents done for your dependent children. So just a brief review. This is something that in our office we really harp on. We want to make sure that anyone over 18 has legal documents in place, because mom and dad can't help you once you turn 18 over certain things, one of them being medical. We've got to make sure that there's someone that mom and dad can talk to the doctors on behalf of the son or daughter that turns 18 and also have access to medical records, right? We don't want mom or dad not having access to the medical records, and now they can't make a good decision to the doctor. So you've got to make sure that these two pieces are done, as well as financial decisions. You want to make sure that if you are needing to call the bank on behalf of your child, or the Discover card, something happened, it was bounced, there's fraudulent charges, Chrissy's in class and isn't answering the phone, you want to be able to call Discover and fix it. You're not going to be able to do that without her power of attorney. So there are certain real things why you want to make sure you've got these documents done for your children. And as I said, this is something that can be done under the Texas Legal Plan. So just as a review, hopefully you know that Texas Legal, if you are Texas Legal members, there are certain great benefits that are afforded to you. And I just want to review some of them today. So one of them is you want to make sure to update your documents. Well, guess what? Texas Legal allows you to create all the basic documents we talked about once per plan year. So you can create them and then update them once per plan year. So meaning, sorry, you can create them in one plan year, you can update them in another plan year. And these documents are your will, your medicals, including the medical power of attorney, the HIPAA, the directive, your durable power of attorney, guardianship declaration, appointment for disposition of remains, trust if you have one. And again, as I mentioned, if you have that family plan, you can do documents for your dependent family members. Remember that you can utilize your plan benefit once per year, and know that if you are using the Texas Legal benefits, you're saving hundreds or thousands of dollars each time you would do an update, right? Versus private paying. And not to mention, if you're doing this, you've got peace of mind, because as I mentioned, having a plan, it doesn't mean you're preventing the bad things from happening, but you're at least putting the people in place that can help you if something does happen to you, either upon death or during life, medical, financial, etc. So I am going to try to answer some questions now. And if you have some questions, go ahead and put them in the chat box. So I'm going to read the first question here. What would I need to update for my trust to bypass probate? Can I keep my bank out of state? Yes, we're not telling you you need to keep your, that you need to change banks. You certainly don't need to do that. But what you want to make sure, and you really should probably go, it's worth having a review session with an attorney just to kind of help you think through what is in the trust. But for sure, your real estate, got to make sure that's in the trust. And then any other financial account that does not already have a beneficiary designation. So your bank account, unless your bank account has a pay on death to someone, which you can do a pay on death on a bank account if you didn't know that. Talk to your banker. You should put that bank account in the trust. Any investment accounts, excuse me, brokerage accounts, anything like that, stocks and bonds, all of these things can go into a trust. If you have a financial advisor, that person can help you with that and with the naming and putting things into a trust. There's usually, if you've done a trust, the attorney will have given you what's called a certification of trust. It's usually like a 1 to 3 page summary. And that summary is probably what you're going to need to give the financial advisor or the bank in order to move these assets into the trust. Okay, it looks like there's another question. As a state employee, can we make a will for both myself and my spouse, or just me? So I'm going to answer that question 2 ways. First of all, if you are a Texas Legal member, find out if your spouse is also a member. If you and the spouse are both members, or maybe you have the spouse and the family are on your plan, then the spouse's will and all those documents are covered as well. But no matter whether he or she is covered on that plan or not, you both should get your documents done. And what you could do is you could ask the attorney where you're going, if the spouse isn't covered, do they offer any discounts? Like, can you get the second spouse at a discounted rate? And more than likely, then they probably would do that. Like, we do that. So I'm sure others would do that as well. But definitely each of you need your own documents. But that is a good question. Each person has their own will. Each person has their own power of attorney, medical, etc. So each individual person has their own set of documents. So yes, you and your spouse need that. Let's see. The next document is, my documents are currently with LegalZoom Texas. Can you accept these? You definitely should have them reviewed. I've seen really bad, I'm sorry, no offense to LegalZoom, but they are not updated according to the Texas law. They do not have things in there. They're not done by, there are attorneys, but those attorneys are not necessarily well-versed in Texas. So I definitely would at least use your plan benefit, have a consultation, have these documents reviewed. So there are some, LegalZoom wills that will actually go through probate and things will all work out. But unfortunately, I've seen some messes where they don't and things do not go according to plan. Worst case scenario is the will is actually invalidated, or just it wasn't done correctly. And the biggest problem I have with things that are DIY is the execution. Were they actually signed, witnessed by 2 witnesses, independent witnesses, and notarized? Is the proper language in the will for the execution? And sometimes they're really not. So I would definitely get that reviewed. There's another question. Any suggestions on how to speak with older parents so they don't think you're trying to put their name on our home or get their money? Oh yeah. Okay. So I have one of these. Actually, two of these. I have. So my mom actually just relocated here, and it's a lot. It's really hard when you're the sandwich generation, right? You've got the little kiddos that you're trying to help, and you've got your big kiddos that you're trying to help. I think the best thing that I would say is just kind of blame it on your own attorney and just say, oh, I was talking to my attorney and, talking about my own will, and I didn't realize all these things that I needed to do. And hey, mom, dad, do you have this document in place? Do you have a power of attorney? Do you have a medical? Because yeah, I'm really concerned. Like, I really want to make sure I can help you if and when the time comes. And she was giving me all these examples of horrible things that happen to other family members and needing guardianship, and I don't really want that to happen to you. So I think maybe the way you bring it up is just kind of gently. I don't know who's celebrating Easter this weekend, but sometimes folks will get together at big holidays and maybe have a cup of coffee, have a glass of wine, just kind of gently bring up, oh, I read this article, or I talked to this person, or I talked to my attorney, and I just really want to make sure that if something does happen to you, mom or dad, I want to be here to help, and I'm going to make sure we can do that. So I think that just be honest and bring it up, but do bring it up. And let's see. Tax benefits to moving assets into a trust. Okay, so I'm guessing that question came from someone that maybe moved here from California. I do want to just let you all know, Texas, if you have, if you die in Texas, the only current estate tax we're looking at is the federal estate tax. So Texas doesn't, Texas does not tax us when we die, right? Texas doesn't institute a death tax because we die. So in terms of, are there benefits to moving your assets into a trust? If you would trigger the exemption amount, and the exemption amount in Texas, or for Texans, the exemption amount you're worrying about is federal. Right now, that's about 10 million-ish per person. It will go back down to 5 million-ish per person in 2024, according to the law. But if you're not at those numbers, you're not going to be worrying about a tax when you die, at least in terms of your assets in Texas. If you have California property, you might still be subject to California laws, et cetera, or if you have another state where you own property. So those would be good things to run by your estate planning attorney. Last slide up. Sure, I can do that. That's easy. Let's go back. There we go. Texas legal benefits. Yay, that's an easy question. Whoever put that in there, yay. Okay, so would the insurance company, let me just try to read this question here. Okay, so the person that asked the question was, it's a good question. Doesn't the insurance company know who the beneficiaries are? They should, yes, since you filled out the information for them. However, best practice is to make sure you have an inventory of all of your assets, and maybe you have copies of who you have the insurance policies with and the beneficiary designations. So no, it doesn't have to be in your will, but yes, you should have that information separate, maybe next to your will, near your will, so your beneficiaries know what different policies you have, and if they have beneficiaries on them, all the better, because number one, you're utilizing those policies that have the beneficiaries, and you're telling your people that you have these policies and who the beneficiaries are. So you do want to keep all that in one place. Oh, I know the beneficiary would need to be verified, but do they have to provide any other documentation with their appointment? You know what? The person that asked that question, if you could just clarify, I'm not sure exactly what that second sentence means, but and if I answered it, great, you don't need to clarify your question. But just make sure that the companies, if it's an insurance policy, the beneficiary is listed, and that you have documentation proof somewhere with your will, powers of attorney, so that if something does happen to you, your beneficiaries and your executor know that you had that policy and who's listed as the beneficiary. So there's a comment for, does foreign property have additional work? Yes. And if you're talking about foreign as in out of the US, absolutely. And best practice there is for whatever country this might be, yes, it's different, but you should have your Texas attorney work with your foreign attorney to kind of make sure everything is covered, because some countries pass, some countries, it doesn't matter what the will says, but the property is going to go to the firstborn son, or you put on real estate, you designate who is going to get what. So the laws vary from country to country. And so the best practice is to have someone in that foreign country that can work with you. So maybe you get your Texas will all drawn up, and then maybe you can work with someone in that other country just to make sure that those assets are all tied up as well. Oh, okay. So transfer on death deed. So I don't love them because the court doesn't love them, because there can be lots of issues with transfer on death deeds. When done correctly, a transfer on death deed is a document that says, when I die, this piece of real estate is going to this beneficiary. Okay, when done correctly. And when I say that, it has to be, the language that has to be in the deed. It has to be properly signed, notarized, and then recorded. The reason I don't love them is I would much rather, let's think about this. If you have someone die and the transfer on death deed was done, we hope that it was done correctly and that property is going to pass. But you should make sure that you have the will or trust in place, because in case something happened and that deed wasn't done correctly, that it can be addressed in the will or trust. So you still have a second way of passing that property if there was an issue with it. Does anyone else have any other questions? Just give it a minute. The presentation. I think I will go ahead and get with Texas Legal and see if I can share our presentation so that they can share it if requested. Yes, I can do that. Just let me know if there's, I'll just have a few minutes if you have other questions. So I think there might be a question. Oops, sorry. Let me just see. Just gonna scroll here. So there's a comment. It says see comment on pour over wills. I'm sorry, I'm not seeing if there's a question about a pour over will, but let me just address what it is. Maybe that'll help resolve the question. So everyone needs a will. Even if you have a trust, you need a will. Because if you didn't put something into the trust accidentally, you need something, a document, the will, that can dovetail with the trust, so that any assets left out of the trust can later be probated and put into the trust or poured over. That's what we call it, a pour over will, because it's coordinating with the trust. So a pour over will is essential. So if you're doing a trust, you absolutely still need a will, because you need a certain kind of will that works with the trust as sort of a little backstop for any assets that you happen to perhaps leave out of the trust, so that they can be probated and put into the will. Sorry, let's see here. All right, so can having a trust set up help protect assets from nursing homes? Okay, so if you have specific Medicaid nursing home type questions, you need to speak to an elder care attorney. There are attorneys that deal with Medicaid. That's not something that my office does. So there are certain types of trusts and things that you can do, but that's not something that I can help you with, help answer those questions. It's a very specific area of the law. So I do recommend getting with Texas Legal and seeing if there are any member attorneys that practice in that area. So let's see, pour over will, cover the need to probate. We discovered over 5 years after death that my father had a gun from World War II. The judge refused to let us add it so we could sell it. So, okay, so there's a couple of issues here. I'm not sure exactly what the anyway, I'm going to let the pour over will. There's a couple things. One, even if you have a pour over will, you still need, even if you have a trust, even if you have a pour over will, you still are going to need to talk with someone after after someone's death to make sure that there are no assets that actually need to go through probate. Because if there are, that's when that pour over will is needed. And if you have an asset that needs to go through probate, you will be using that pour over will. Having the pour over will doesn't keep you from probate. It's in case there's something needed, it will be used. This one question is about discovering a 5 years after someone died, that the father had a gun. And so the one issue with the 5 years is that you have in Texas 4 years to probate a will. So at that point, after the 4-year mark, the will is, if you've waited over 4 years to probate a will, then the will is presumed revoked. So that's the problem with that. I'm not sure exactly what happened in this particular situation, but that's their question. The cost of maintaining a trust. Well, I think it's a good rule of thumb to probably have things looked at every 3 to 5 years to make sure that you have your, that it's properly funded and that your documents are doing the right thing for you. But in terms of the cost to maintain a trust, it might not be anything, right? As long as from year to year, you don't have anything that's moving out of it. The trust, if you're doing a revocable trust, it's your social security number, so you're not paying taxes on it. So there really shouldn't be any cost other than potentially attorney's fees if you're updating your trust. But again, if you're a Texas legal member, you can use your plan benefit to make those updates. So there's another person that's asking about a nursing home. I'm going to direct all of the nursing home questions to Texas Legal to talk to. You can get maybe there's a member attorney that covers elder care planning. That's just not something that I do, so I'm not going to speak to that. But know that there are certain types of trusts and certain types of planning tools that you can do if you're worried about folks in nursing homes and protecting assets. There are certain things that you can do, but you need to talk with certain attorneys about that. There's an attorney that I know. I'm happy to share his contact information with Texas Legal in case they can't find a member attorney, but I'm sure that there are member attorneys because we do refer several clients in our office to a firm in Texas or Austin that they're great with elder care questions and planning. So I'm just going to give it another minute to see if there's any other questions, and then I think we're going to go ahead and wrap up because it looks like we're at the end of questions. Okay, so I think I'll take this as the last question since somebody did hopefully smile when I said about the cost of assets skyrocketing in the last little bit because of Texas, or real estate appraisals are pretty crazy now. So the value of the property is skyrocketed. I think it's a good time to redo the trust and will. So it may be a good time just because maybe your decision about whether you want to put that asset into a trust, maybe you want to avoid probate and put your asset in a trust. Yes, sure. But just because something has skyrocketed in value doesn't mean you have to put it in a will or trust. However, you should be looking at your documents, making sure that you know who that house is ultimately going to pass to, and are they still the correct recipients of that, and are there other things you might want to do with that? Do you want to have it sold, whatever? So it would be it's definitely a good thing to run by. You might as well make it a consultation with someone to review what you do have, and then maybe kind of talk through things you hadn't thought of, and are there other things that need to be done. But just because something has increased in value doesn't mean you need to update your documents. All right, well, I am going to sign off, and if you have other questions, for sure you can forward them to Texas Legal. And on this last slide, I do have our contact, our firm's contact information. Texas Legal can certainly help you set up an appointment with an estate planning attorney to have your documents reviewed and updated. But again, I appreciate you being here today. Thank you, Texas Legal. Again, my name is Melissa StoneMyers with StoneMyers Law.